What's up, guys? Cannabis Review TV, and today I wanted to go over California's 2012 legalization push, as well as a few bills that have been introduced to the California legislature and a court ruling that came out a few weeks ago. So let's jump right into it. First, there's three bills that have been introduced, and the first one is AB 2465, and this will require all medical marijuana patients to have a state photo ID as well as register their address where they grow medical cannabis. And according to Dale Granger from the California Normal Association, this is completely unconstitutional, and it breaks the right to a patient not to be arrested upon the written oral recommendation from a doctor. And law enforcement claims they want this bill to pass so they know whether or not a house that is growing cannabis is registered and that they are legal or not before they have to enter the house. You know, right now they have to enter the house, ask a few questions, you have to prove your paperwork and all the other good jazz, and there's no database right now for this, at least is not one comprehensive as this bill would create. So I'm definitely not in favor of the bill, and I just think it's an invasion of privacy, and I don't think you should have to go through all these extra hoops just to enjoy medicine that's already constitutionally legal in your state. Now, the second bill is AB 2365, and this is an amendment to the Family Code. And what this bill does is require that courts acknowledge and bring up medical marijuana use in a civil case for, child support, custody, stuff like that, for the family civil cases like this. And the bill would also require that parents notify the court, or that the court is aware of any prescribed controlled substances, and these are all prescription pills and medications, which I'm kind of for, but it also specifically states in the bill for medical marijuana as well. And this to me is a very bad bill, because just because you use medical marijuana does not mean you are a bad parent, not by any means. And sadly today, marijuana is still looked down upon and is, just not something that is really understood in law enforcement. So this will definitely create a biased judgment towards medical marijuana users. And once again, I don't think this is a good bill at all. That is AB 2365. Now, the third bill, and this is one I'm totally in favor for, is AB 2600, and this prohibits the DMV from revoking a person's driving privileges, or suspending the driver's license for simple possession of cannabis, and that is for possession that is 1 ounce or less. Currently, a license suspension is automatic for any amount of cannabis found and someone involved in driving a motor vehicle and stuff like that. So definitely a positive bill, and I'd like to see that one passed. Now, moving on to the court ruling, this one I pulled off Nuggetry News, and it's also on the Huffington Post, is that the court has ruled that cities cannot ban medical marijuana collectives. And a 3-judge Court of Appeals in Santa Ana ruled Wednesday, March 1st, that cities cannot prohibit or place restrictive zoning laws on medical marijuana collectives. Now, we've seen already since the federal intervention and the raids on the dispensaries, we've seen a lot of the local cities and municipalities stepping up and thinking that they have the absolute right to just completely ban collectives in their town. But according to Justice Richard M. Aronson, he was a part of the 3-judge Court of Appeal, he says, quote, "A local government cannot ban as a nuisance exactly what the legislature contemplated what would occur at a cooperative and collective cultivation site, medical marijuana cultivation site." So pretty much he's saying that this is what has to go on in these collectives, and you can't classify that as being a nuisance because it is recognized form of a nonprofit business, and it is in the Constitution in Prop 15, obviously. So this is actually a good court ruling, and there's two things that come out of this, and aside from the uncertainty, there's two things. One, cities cannot ban collectives, so now you have a basis to go to the court and you can use this ruling as a grounds for argument against municipality trying to close down your collective. And the second thing it does is in the wording of the ruling itself, it would be interpreted by law enforcement that collectives may only sell medical cannabis that they grow on site, because that's what the collectives are supposed to be there for, is to cultivate the cannabis. So the current ban, on collectives could still be upheld, or we could see them, completely repealed under this ruling. But I think what we're going to see more out of this ruling is that collectives, once again, could only sell the cannabis that they grow on site, and this would have a tremendous impact on what's left of the medical cannabis community in California, and it would force a lot of dispensaries and collectives to go out of business. So we'll have to wait and see how well this ruling really is for the medical cannabis community in California, but I figured I'd share that with you guys. Now on to the 2012 legalization push. If you guys remember, I did a video last October, I think it was called Feds to Curtail Medical Marijuana in California, and I sent out letters to all collectives within 1,000 feet of school, and most of those collectives have since shut down. The other thing we've seen out of this is if a local county or city wants to ban a dispensary, they have the utmost support of the feds, and so they'll call upon the feds to help raid and shut down the dispensaries that are operating in the municipality. So that kind of sets the precedent for the legalization push in 2012, as well as Prop 15's failure in 2010. A lot of money was spent on Prop 19, and it failed. It didn't pass, and combined with the current climate for medical cannabis in California, whether it be the IRS 280 tax rulings, the feds closing down dispensaries, the uncertainty in the political atmosphere for medical cannabis, we've seen a lot of collectives and dispensaries, whatever, get shut down, and this has really taken away a lot of the funding for the 2012 legalization push, which I might add isn't looking too good for California. The second thing that's kind of hurting California right now is there's four initiatives rather, that have been brought into the scene for the 2012 legalization push. Excuse me, my mouth's getting dry. I didn't bring any water out here with me. But so yeah, what I'm going to do now is go over those four initiatives and give you my opinions on them. The first one is the Regulate Marijuana Like Wine Act, and this one's pretty much dead on arrival. And what this would do is have the Department of Alcohol and Beverage control the sales of marijuana and regulate the taxes of it just the same as they already do for alcohol. And what kind of killed this bill is it was filed early on earlier last year, and so the deadline for them to collect their signatures, unlike all the other initiatives, which is April 20th, is actually pushed forward a month, and now it's March 20th. So they've failed to reach the number of signatures that they need for the initiative, and it's very unlikely that they'll get this done in the next few days here. So that is the Regulate Marijuana Like Wine Act. The second initiative that they have going for them is the California Cannabis, Hemp, and Health Initiative. And this is brought forth by Friends Disciples of Jack Hare, and this is from the Reefer Raiders, as they call themselves. And every year since 1980, they've been able to put a legalization initiative on the ballot, or at least attempted to. And this one has till April 15th to collect the signatures. And what it would do is legalize cannabis, hemp for medical, industrial, naturalistic, and recreational use. So this is a decent initiative. I'll leave the website down below for you guys to check it out, but once again, it is not going to be able to collect enough signatures, and this is due to, like what I was explaining previously, the lack of funding and the competition between all the initiatives. Now, this is the next initiative I'm about to talk about is the most popular initiative, and it's supported by every medical marijuana patient advocate group in the state, as well as a few national groups like NORML and SAFER. So this is the Repeal Cannabis Prohibition Act, and it's probably the one that I support out of the four. And what this does is simply repeals the California state criminal statute for marijuana possession for anyone who is 19 years of age or older. You still have the driving while impaired rulings or statutes for cannabis that will stay the same, as well as anyone under the age of 18 will not be able to use cannabis and still will be subject to criminal charges that are on the books currently. What this also does is 180 days after the bill would be enacted, which is sometime in July of 2013, it would also give the California State Legislature the option to create a California Cannabis Commission, and this commission would be responsible for developing regulations for commercial sale of cannabis, as well as licensing and tax collection. So that's pretty neat. Also, what this does is allows anybody in the state to grow a 10 by 10 or 100 square foot garden and possess up to, I do believe it's 3 ounces of cannabis. So this is one I definitely support. You can check it out at repealcannabisprohibition.org, and this one is still on track to collect signatures. It's still, you know, up in the air as whether they will be able to or not, but it's still on track to collect signatures by the deadline, which is April 20th. And so far they need to collect 504,760 signatures, and they're on their way to reaching that, but it's still iffy as to whether they will reach that goal or not. Now, the fourth initiative, and this is one that's really cool, I definitely support this one wholeheartedly, and this is the Medical Marijuana Regulation, Control, and Taxation Act. And what this does, or excuse me, it's also known as Initiative 11-0098, which introduced on December 20th, 2011. And what this does is it'll create a medical marijuana state tax, a sales tax, that will sit at 2.5%. And what it would do is with the funds of this tax, it would seek to create an agency called the Bureau of Medical Marijuana Enforcement. This will be a self-regulating agency, and it'll be made up of various state agencies, patient advocate groups, experts, and medical marijuana physicians. So we'll get more into the BMME in a minute here, or the Bureau of Medical Marijuana Enforcement. What this act also does is reinstates and reinforces patient civil rights, which were in Prop 215 but have since been neglected by the courts or dismissed or not enforced or upheld. So this would reassert those rights. Also, with any extra funds that are made from the taxes, those funds will go to the California Medical Cannabis Research, also as well as grants for medical marijuana education, low-income assistance, and also the MADI Fund for Emergency Services, and the rest of it will go into cultivation research for more energy-efficient means to cultivate medical cannabis. Now, with the tax, it would also create, like I just said, the Medical Marijuana Enforcement Bureau, and this would be established under the Department of Consumer Affairs and Alcoholic Beverages, as well as the California Medical Board. And the Bureau would operate under a 21-member board, representative board. This board would be consisting of members of various state agencies, patient advocate groups, physicians, and experts who are knowledgeable in cannabis and medical cannabis. Anyone in the business of cultivating, distributing, selling, processing, manufacturing, and transporting cannabis, medical cannabis, would be required to be registered or required to register with the Bureau of Medical Marijuana Enforcement, and for any collectives or any collectives that have already since been giving the grant or the go-ahead or licensing and regulation in certain cities and municipalities would be grandfathered in starting on July 1st, 2013, and they would have a 3-year grace period before they had to register with the Medical Marijuana Bureau, or Bureau of Medical Marijuana Enforcement rather. And yeah, this is a pretty cool bill. Ooh, mosquitoes are coming out. and it would, create a statewide medical marijuana for-profit industry that would collect tax and enforce itself with the money collected from the tax. Also, what this does is it places language in the act or legislation that says that cities can no longer ban dispensaries, and it would require one club or medical marijuana collective per county and one club per 50,000 inhabitants in that county. Local municipalities would still have the ability to ban collectives, but they would have to override it with a ballot initiative, and the people would have to vote on that. And this is only for municipalities with over 50,000 people. So yeah, this is a badass bill. It's one I definitely support, and it pretty much creates a for-profit medical industry, cannabis industry in California, and it kind of mimics what's already been set up in Colorado, and it would be a great example for all other medical marijuana states to follow. So definitely something cool. Out of the four initiatives, I really support the Repeal Prohibition Marijuana Taxation and Regulation Act. I think they both go well together, hand in hand, and as of right now, both of these acts still have a decent chance of making it by April 20th, but still, like I said, it's very slim. There's not a lot of funding to collect signatures, and there's a lot of, turbulence in California right now, especially with the federal raids and, the uncertainty of a lot of these collectives, the amount of back taxes that they owe due to the IRS 280 clause that's designed for drug kingpins, not for legit nonprofit businesses. So that's just a little look at what's going on in California this year for the 2012 legalization initiative. I hope you guys enjoyed the show, and as always, stay tuned, stay stony, and stay subscribed. Peace.